sponsored by the Swiss National Science Fund. We had the opportunity to publish the book on the choice of law in international commercial contracts, edited by or published by Oxford University Press in 2021, containing around 70 jurisdictions approach to choice of law. And because we thought that this was such a nice group that worked on this project, including of course Béligh Elbalti, whom we will hear today, but also Jan Nels. I saw that Jan Nels is participating today. Hello, Jan. And Thomas Graziano, and then the follow-up project, which is what Agatha presented so nicely just a minute ago. The Dataverse was a project, common project of the University of Lucerne with the University of Johannesburg. Jan Nels as the main person there, but also Isa Fredericks, who is also a teacher there, and Geneviève Sommier of the University of Montréal. So this was the directors board, but we had a lot of collaborators, including many of you listeners today. So thank you all for being so helpful and interested in these projects. Now, today we have the privilege of welcoming another very important person, Horatia Muir Watt, professor at the University in Paris. Her her path was from, I think, Scotland, if I'm informed correctly, to France, where she stayed for the rest of her life, starting, I think, her PhD in private international law at University of Panthéon-Assas, Paris 2 in 1985, and then passed her aggregation examination in private law in 1986. She is a tenure professor in private international law and in comparative law, and taught at various French universities, ending up at Sciences Po in 2009, when she participated actively in the creation of the law school. So we have this thing in common too. We created a law school, and we are very proud to have you, Horatia. She's a member of the Institute of International Law, has been for almost 15 years now, and also of the Institut Universitaire de France. And she is a director of the Revue Critique de Droit International Privé and of many other publications, and runs a private international law and global governance research group. Her publications are many, many, many. You can look them up. We will speak, as Agatha has announced today, on choice of law, and I have two publications in front of me that deal with it. One is the one that Agatha entered in the Oxford Handbook of Institutions of International Economic Governance and Market Regulation, where she wrote the chapter on party autonomy in a global context, the political economy of a self-constituting regime. But I also have a book in front of me that she authored herself, The Law's Ultimate Frontier Towards an Ecological Jurisprudence, which I think is also a fruit of her course in The Hague that she gave the Cour Générale, I think in 2017. Then with the assistance of Agatha, another common denominator. So welcome, Horatia, and I have two panelists with me that have graciously agreed to lead the discussion on this topic of choice of law. One is an old colleague of Horatia. I think he even spent the time as a student with her in Paris, and that's Gérald Goldstein. He is now a professor at the University of Montréal, so one of our partner institutions in this project, the University of Montréal Law Faculty. He's Professor Associé, and he has also written quite a bit on private international law. One of his famous works is, I think, his doctoral thesis, De l'exception d'ordre public aux normes d'application nécessaires, which he published in 1996. But he's also the author of a Traité de droit civil, so he has a very ample field of research. But he told us when we prepared for this that his love is private international law, and has been ever since he wrote his thesis in Paris and was taught by Professor Paul Lagarde, which who may even be listening in today, of one of the very big names in private international law. Finally, we have Béligh, or Benkei as he's called in Japan, Elbalti, whom Agatha already introduced. He is a professor in Japan, coming from Tunisia. He was raised and educated in Tunisia and then went to Japan for studying private international law. He obtained his PhD there in 2014 and worked at Kyoto University as an assistant professor and at Doshisha University as a visiting lecturer before assuming his post as an associate professor at the Graduate School of Law and Politics in Osaka in 2017, where he has worked ever since. His main research areas are Japanese law, private international law, international civil procedure, comparative law, and Islamic law. So he's, I think, an excellent expert in two very important regions of this world, especially when looking at the global south, namely Asia and the Middle East, Northern Africa. So I'm very blessed to have these three experts today here that have studied and taught in so many regions and about so many culturally different approaches. Now, the topic of today, as you have seen, is party autonomy, sacred principle or legal fiction. And I know that Horatia Muir Watt is someone who really not only represents the traditional approach in private international law, but she's one of the most prominent critical analysts of the traditional approaches in private international law. And many of her writings are a vivid proof of that. So our first question to Horatia would be, what prompted you to revisit party autonomy specifically through the lens of political economy rather than through doctrinal critique alone?
Oh, well, thank you. Thank you for the question. I must say how wonderful it is to be here with all of you, and put a particular thanks to Agatha for getting such an ambitious project off the ground. It doesn't surprise me, but it's still very, very impressive. So what prompted me to look at party autonomy under a political economy analysis? I think this goes back a very long time. Basically, the whole question is in my first Hague special course on economic aspects of private international law. At the time, I had been interested in a critique of law and economics generally, And I was particularly concerned with the way in which this critique had not reached, let's say, party autonomy in private international law. And so the obvious place to start was a political economic critique of this particular tool that had, in my opinion, favored the neoliberal turn in private international law. So I think that what I need to say about this is that this critique is of a particular time, a particular economic regime that was the predicate, if you like, of the development of party autonomy. I'm not sure that everything that I've written since 2005 to 2019 is presents a complete picture now of exactly what's going on.
Thank you very much. And I would like to give the floor to first to Gérald Goldstein, because he has a very interesting question in connection with your so-called second look theory. Gérald.
Hello, do you hear me well? Yeah?
Yes.
Okay, thank you. So, well, first, I'd like to ask you a very simple question. Could you just explain for the auditors what do you mean by the second look doctrine or theory? For those who don't really precisely remember it, there might be some, but I've got, of course, a more precise question about that. So, what you want to answer right away, or shall I ask the question, the more precise question right now? Daniel?
Yeah.
Horatia.
More precise?
Perhaps we could have the two at the same time so I can contextualize the question.
Okay. So in your article, you seem to be saying, I think according to the case law, that the second look doctrine doesn't seem to be so efficient. How pessimistic is it to think that it is not efficient? And I've got another sub-question. This is a general question, but I've got a very specific sub-question dealing with that. You mentioned that judges are not well equipped they are less equipped than arbitrators to assess the merits of the case in economic terms. But in the perspective of a control usually exercised through the 1958 New York Convention or the conditions, where do we need more precisely? Could you explain us where do we need precisely to have such an economic analysis while using the condition to control an award?
Okay, thank you very much. Well, the second look doctrine, I mean, the idea of the second look comes up in many fields of the law. It was something that was put in place by the US Supreme Court to compensate, if you like, for allowing arbitrators to decide on questions that, briefly put, involve public policy. In other words, if the arbitrator would be in some way abusing power or making mistakes, etc., in dealing with these very, very important issues, and in particular competition law, so it's in that context that the second look doctrine emerged, then at the enforcement stage, national courts could come back in, if you like, back into the process by exercising a second look and, for instance, refusing enforcement. So it's a very simple idea. It's a compensatory principle. Why do I think this is inefficient? There may be a time factor here. At the time this doctrine was put in place, and before various safeguards began to be discussed, it was quite clear that the second look doctrine wasn't efficient, in that it presupposes that the arbitral award is being enforced in a place where the courts are going to implement some kind of a control. And of course, arbitral awards may be enforced without state control, or the place of enforcement may not be the place where the actual public policy is in force. There were several examples of this, but what I do want to emphasize is that the second look doctrine is not the only way in which one can compensate, if you like, for delegating various public policy issues to arbitration, and various gateway doctrines, for instance, in arbitration on arbitrability, are also an attempt to find equivalent safeguards. Why did I say that courts aren't necessarily equipped in the same way as arbitrators in deciding economic issues, such as those that arise in competition law? Well, I think the fact is that they're not, in that they're usually generalist courts deciding these cases. On the other hand, I totally agree with your point, and I don't think I denied that. I think we're in absolute agreement that what is asked of the court is not to second guess the arbitrator on an economic issue, but to put up a barrage in case the court's own public policy is in some way affected.
Thank you very much for these explanations. And I think Béligh or Benkei would like to add a question in this regard, right? Benkei?
Yeah, thank you very much. First, I would like to thank you, Daniel, for this generous introduction. And thanks, Agatha, for inviting me to be part of this panel today. I think many other persons would have been more qualified, but I'm very happy to be engaged with Horatia, whose work has been very much influential. Like when I started my thesis, if I allow me just a few words, when I started my thesis, I read her work published in Répertoire de droit international on foreign judgments, this kind of series, which shows basically the classical, let's say, approach of Horatia as the scholars of private international law dealing with classical issue. And then little by little, there is this kind of shift. Well, she explained that, how she was involved in political economy and so on. And well, you could notice that from her first edition of her book, which tried to involve these issues of political economy and global governance, and then becomes like global governance altogether, which is quite fascinating and interesting because it's clearly opened the eyes on some subtleties of the discipline and the role it may play today, not only for private international scholars, but also in relation with other disciplines. And as Daniel mentioned, well, since I have kind of diversified background coming from Tunisia, living here in Japan, and now developing certain interest in private international in Africa, then when I read Horatia's work, I have this kind of view of global South perspective or different perspective. So particularly when it comes to this idea of a second look presented here. So it's basically a second look is a control of the decision or the arbitral award rendered by an arbitrator or probably rendered by a foreign court. And then this the idea that is developed by Horatia in her work by saying, well, there is a kind of, well, it's weak, it's not working correctly. And I was connecting this idea to development in other regions of the world. So for example, whether this kind of weakness can be nuanced very much when it comes to certain countries or certain regions. Particularly, I'm thinking of China, where China clearly adopted a modern system of private international law with recent codification of choice of law, of arbitration, recently reformed, 2023, international jurisdiction, and so on. But then you have some scholars, very interesting scholars, who try to develop the idea of national interest. So they say basically this all goes within the national interest of China. And therefore, when it comes to this idea of second look, well, probably the French approach, which talks about transnational public policy and try to enforce as many arbitral awards as possible, probably doesn't work in other countries like in Vietnam, Indonesia. So we have the participants here from Indonesia. They can tell us their approach about enforcement of arbitral award in Indonesia, or any other countries like in the Middle East. For example, we have certain influence of Islamic Sharia, where you have interest, for example, is not enforced by courts in Saudi Arabia or in the UAE. So there you have this idea of a second look, well, that is weak in some country, probably in Western Europe. But when you look at other region of the world, probably the situation is different. And I'm wondering, what are the views of Horatia on this aspect?
Mm-hmm. Thank you, Banke. It's really a pleasure to interact. And I must say, you're absolutely right to push back on the point that you make. I think this whole writing describes a moment. It describes the translation in terms of private international law of the neoliberal turn in the West, let's say. Which was predicated on a certain economic regime or political economy regime that was being globalized. Now, I think you're absolutely right.
Oops.
Daniel, perhaps you want to say something?
Yes, it's not only frozen on your screen. Could you please repeat the last part, Horatia? You were frozen for a moment.
Sorry, I can't even remember what I was talking about. I think that I was saying that
geopolitical change, so that's what you said.
Yeah, absolutely. What I was describing was a certain moment in the political economy, the global political economy. In other words, it was a Western idea. It was predicated on a neoliberal turn. And I'm sure, and this was a way, of course, of globalizing a certain idea. It was a certain form of global governance. I'm absolutely sure that it's not the same now that, or it doesn't describe a world situation anyway, at a time where the geopolitics are totally different. And the example of China, I think, is absolutely excellent. I think it does show that party autonomy, other tools, are never purely instrumental. We can look at the way in which party autonomy arbitration has been incorporated in the One Belt, One Road. We can also see how the Hague Convention on Judgments has actually been instrumentalized in that context. Because it ensures the interoperability of judgments and probably awards all along the value chains, if you like. But I think that from China's perspective, it's no longer what we would identify as a neoliberal regime. It's definitely a state compelled regime. As for the Middle East, there I'm absolutely not an expert. I'm sure that the political economy is different. I think that we're looking at a changing world anyway, and it may be too early to judge. But I'm sure that in the West, we are past the neoliberal moment, and we're, let's say, transforming into a completely other political economy regime.
Thank you very much. I think, Benke, you have a follow-up question in that regard, with regard to the inversion of law and markets, right?
Before moving to the idea of inversion of law and markets, probably if I can ask Horatia about an addition to this theory of party autonomy, because in your work you focus more on litigation and arbitration. However, since 2018, there have been certain development when it comes to international mediation. When you see that how the Singapore Convention was so swiftly prepared adopted, ratified. You have certain countries, including Saudi Arabia, including Qatar, including Japan. Japan usually doesn't ratify convention, but it was one of the first parties to ratify this convention. Now it is in force. Then where is the place of international mediation in your analysis of party autonomy? Is this something that confirms your theories developed in 2023 and before, or something like probably challenge a little bit the foundation? Because mediation is not about the law, it's basically satisfying the party's interests, sometimes with the help of the law, but probably not in application of the law.
Yes. Well, there again, it's a very good question. This is a mediation developed after my inversion thesis, and I think it's part of a new move. I think that as in arbitration, there is a hiatus between the idea and its implementation. And so I fear that the dangers that I saw in the party autonomy arbitration context are actually valid too for mediation. What I can see is a pattern emerging, an industry, a professionalization, a displacement of arbitration to mediation, and something that I've seen in many cases, which is an association between arbitration and this new concern for consulting indigenous communities about investment projects. And I fear that there may be something like an epistemic washing going on in that context. It doesn't mean that I think that mediation is bad, obviously, and I think it could indeed correct some of the points on which arbitration can be criticized, including expense, perhaps. But my point is always to be aware of the possible downsides of all these moves. So I sort of come with an epistemological position of distrust when I see an industry developing. But maybe there again, it's too early to judge. And there again, it's not any more than arbitration. It's not a general condemnation. It's pointing out what may be wrong.
And
Yeah.
and what could be done to change that, to make you more trustful, to more confident?
I think, well, goodness, that's a big a big agenda. Obviously, there are questions such as transparency, publication, a survey or surveillance, let's say, of fees for the mediators and arbitrators, better education in what public policy issues might mean, what it might mean for local communities. I think that we have to dig deeper too. In other words, ideally, and I realize that this is very unfeasible, we have to think about the imaginaries that are present in global governance and understand that there is a symbolism and that there are power struggles that are going on under an apparently smooth surface. And I think this is precisely when we think about China, for instance, the whole field of power struggles on the global scene is changing. And so I think that one of the things that we need to do is to connect moves in the apparently disconnected private international law sphere with wider political, economic contexts. So it's perhaps a question of teaching and education and not disconnecting parts of the law that fit in a wider or more holistic context in which there are a lot of struggles going on.
Thank you very much. I think that's a good transition to our next question. Benke, with your permission, I skipped the one that we wanted to ask about inversion of markets in the interest of time, because I think most of our listeners are lawyers, and they're maybe a little bit more interested in legal aspects than economic aspects. And for that purpose, I would be interested in hearing more about the legal possibilities to contain the dangers you described, especially with regard to the so-called overriding mandatory rules. Benke, would you like to follow up on this?
Yes, so basically the thesis of Horatia is giving a lot of party autonomy, is developing extraordinarily well, and it probably is not only a technical connecting factor that has developed in classical private international law, but is a political and instrumental tool for new ideology, new liberalism. However, this developed in parallel with proliferation of overriding mandatory rules.
Mhm.
And the question here is simple. It's like, well, can overriding mandatory rules compensate this kind of regulatory erosion produced by party autonomy? Or what is your vision of sometimes this kind of aggressive, sometimes proliferation of overriding mandatory rules and in connection with party autonomy in your description of its role within neoliberalism, as you understand?
Well, I think that the
Frozen again.
Frozen.
Yes.
type of approach to private international law. I think that
Horatia,
yes.
you were frozen again. Could you start with answering the question again, please? Sorry for the technical problems.
Yes, sorry about that. I would say that Benke is absolutely right in describing this perhaps aggressive proliferation of mandatory rules. I think it's, first of all, the sign that we are past the great neoliberal moment and we're back in a context in which reason of state is coming back. And I'm putting that obviously in inverted commas because it's a political economy of a long time ago that's coming back in the form of state interests. I think that the answer may well be in Gérald's work. In other words, probably what is essential is to understand that instead of proliferating these weaponizing, if you like, mandatory rules, there is a simple tool which is public policy, which works on a case-by-case basis, and that provides a very good defense if certain national interests are being threatened, let's say. I think it's a better method than the proliferation of mandatory rules.
Maybe I give the floor, yes, to Gérald, who is the specialist, of course, in public policy since 1996 at the latest.
I just want to put this into perspective because we all know that mandatory rules and public policy are very much linked to the jurisdiction of the judge. Mm-hmm. So the simple way to avoid that is to change the jurisdiction. So we cannot avoid talking about mandatory rule in the void. We have to figure out and try to understand that, I mean, the game dealing with jurisdiction is overriding easily these mandatory rules. Except, of course, if you have to have a decision executed in one specific country, but if not, you can easily avoid these mandatory rules by just choosing another jurisdiction, I think. What do you think?
Well, I totally agree. I think that that there are even specialists in playing the systems. So that may not be the normal case of let's say, the run-of-the-mill case of parties who are in good faith, etc. But if you take the example of voucher funds, who have actually elaborated techniques in which forum shopping is designed all the time to avoid particular mandatory rules and to profit from something like more minimal requirements of public policy. So I agree, you're absolutely right. I mean, this is part of the problem. The problem is that as long as you can change the forum, then mandatory rules don't help. And this is a point that's been made in competition law a long time ago by Luca Radicati, and plays out ever since. Of course, you can avoid mandatory rules by changing the forum. That's why there are people who think that it would be a good idea, or perhaps even feasible, to elaborate some form of transnational idea of public policy or mandatory transnational principles. But for the moment, that hasn't happened, unfortunately.
And it has become even worse with the possibility of choosing non-state law. Gérald, would you like to ask that question also?
Yes. You are mentioning in your article very specifically, in a very clever way, that state law, strangely, do not accept non-state choice of law, but as a matter of fact, since public policy and mandatory rules trump this choice of law anyway, so what are they afraid of? Why don't states just broadly accept this choice of non-state law? I mean, my opinion was they should not accept non-state law, but I was wrong, and you convinced me by reading your article. I changed my mind. But so how come states insist on this avoiding non-state law? Why?
I think there are two types of answers to this. One is that I think you're absolutely right in your comment on what I said, that the problem is the same as state law. In other words, as long as you've got something that trumps, in other words, say an exception of public policy, then you have a means of safeguarding against the risks that might exist in choosing non-state law. Of course, the trump only works as long as the forum is ready to implement it. So we come back to the same problem. I think maybe that this is a question of imaginary. In other words, that there's no coherence in this position. I think that states are afraid, or legislators are afraid of the very idea of private lawmaking. So that has been a fear for over a century, le contrat sans loi. It suggests something very, very frightening. I think that states at the same time encourage arbitration to a certain extent. They encourage private codes of conduct, many private regimes actually that are allowed. There's no coherence in all that. What is actually to be feared? Well, it could be a lot, and it could be actually very little. I think that if, for instance, corporate norms are allowed to prevail, then there is a risk that a lot of state public interests are sidestepped. On the other hand, there are other forms of private lawmaking, for instance, religious lawmaking, in which I don't really see why there is such a risk to state interest. So I would give a nuanced answer on that, but I think that the implicit question in your or the implicit point in your question is you're absolutely right. There's no particular risk in private lawmaking per se, but we need to have a more granular approach and saying what are the private norms involved here.
Yes, Gérald?
That is good as long as we need a judge. If we don't need the judge, like in blockchain technology, nobody needs any authority, then, of course, you've got non-state rule and you've got people who agree with that. So this is total free autonomy, and they can agree on anything, any crazy type of contracts. And there is nothing we can do about that. That's a problem. This is a real risk, I think.
I totally agree, and I think that this is a new problem, right? This is not only the political situation and the geopolitics, but it's the question of the rise of a completely new political economic regime, which is, some people have called it techno-feudalism, for instance. I think we need to reimagine all our tools. So blockchains present a whole other world of difficulties, and we're still thinking in terms of a traditional paradigm, which is you're absolutely right, a judge-based paradigm, and even an arbitrator-based paradigm. Once we've got out of that, we're addressing a whole series of new problems, and I don't have an answer to what we do with techno-feudalism.
I would be interested in you giving me an example to convince me that this is a new problem.
Well, I think I'll go back to Gérald here, but I think that we've had old ways of
But it's us.
What is it?
It was us. No.
a free choice of law. So there's a pattern, but our pattern now is that we're moving out of a world in which we could always count, or at least we had an imaginary of being able to count in last instance on the intervention of somebody or something that protected us. It was the liberal imaginary, and I think we're beyond that now.
Unfortunately, we didn't hear the first part. I would just, for this, in the interest of our audience, be very much interested in seeing a concrete example which makes this situation more dangerous than before blockchain technology was there.
Okay. Well, I think that blockchain technology is merely part of a much wider system. And what I was saying, that you may not have heard, is that we're changing paradigms, and that we don't have this. Gérald talked about crazy contracts. I would think more of fraudulent contracts and money laundering. We don't have this ultimate protection that we imagined that we had, even if actually the system was probably faulty. But I think that we have to be aware that way beyond the question of party autonomy, we're in a changing world in which we don't have the same, let's say, political regime in which we have always counted, perhaps since Hobbes, in some kind of a protective state arrangement, even though obviously it didn't necessarily work.
Thank you. Now, Wenke, you would like to ask a question in the context of the so-called methodological slippage in private international law, right?
Yeah, exactly. I think this fits in the description now given by Horatia, because I think for those who, listener who are not familiar with Horatia works, probably they would miss something, because they need general framework. So the general framework, and I would like that Horatia would explain it, which is about this shift from liberalism to neoliberalism, with some safeguard within the liberal framework, but then probably the change of paradigm with maintaining the same requirement that led to what she calls slippage, methodological slippage in private international law. So can you give us a general overview about this? And probably we can connect it later with the discussion about non-state law and its relevance.
Yes, certainly. Well, very briefly, what I was trying to apply to private international law and the use of party autonomy was the Foucauldian description of the shift from a liberal idea of what's the relationship between states and market to the neoliberal. This is the inversion thesis, right? So individuals, private actors became the entrepreneurs of self. They were able to opt out of state regulation by choosing a different law. Those are all signs of this neoliberal inversion. Neoliberalism is basically the inversion of the relationship between the public and the private, right? Instead of having a sort of benign state supervising the market became the propeller of much of the state action. And so I was looking for signs of that in the use of party autonomy in private international law, which seemed to me the ultimate or emblematic example of the takeover of the public by the private. That was described, that's what I used in my Hague lectures so long ago. It's the mechanism of regulatory arbitrage in a federal system, for instance. It's exit from a particular state regime. It's barrier crossing. And so what do I mean by the methodological slippage? There's a slippage from the liberal to the neoliberal, but I also used the idea of methodological slippage to show how an idea that was initially limited to commercial contracts actually expanded out of that, and the idea of autonomy, which of course comes from liberal contract theory, was imported into private international law to justify very free choice of law, actually moved into the arbitration area. And you can see a slippage between the signification of party autonomy in contract to the idea of arbitration as an autonomous system. And that's the slippage that I was pointing out. In other words, there's an imaginary which is actually at the basis of the whole global neoliberal order. There again, as I was saying to Béligh earlier, this may well be a thing of the past. I was describing a particular moment, and now that state interests are coming back to the front of the scene, they're not even disguised anymore in terms of private interests. The slippage there again may be different.
So can we talk about reversed slippage?
The word slippage.
Reversed slippage. So to come back to traditional.
Yes, indeed. I just read these days about a new Swiss Supreme Court decision that was issued in March of this year, which is a very interesting decision regarding the enforcement or the trying to enforce an arbitral award from an LCIA arbitral tribunal, which I think in which English law was chosen as the law governing the merits. And that was between a company an island company, which was factually dominated by Russian individuals that were subject to sanctions, for example, in Switzerland against Russia and Russian individuals in the context of the Ukrainian war. And the Swiss Supreme Court ultimately followed the defendant in the enforcement proceedings in Switzerland by confirming that this claimant company was dominated by Russian individuals who were subject to the Swiss sanctions, and therefore the award was not enforced. So that would be a proof of the reverse slippage in some ways, right?
Definitely. I think that the geopolitics are coming to the fore. And I think it's just, we can see that none of these regimes are not merely instrumental. In other words, we can't isolate them from their context. So this reverse slippage is a reflection of the whole change of scene in international relations. And there again, private international law is not disconnected from that. On the contrary, I think we have to put it back in its context. It's not surprising that this reversal, or the reversal of the reversal, let's say, is actually taking place. I think that's a fabulous example. I wasn't aware of the case, although I'm sure it's on the Dataverse, and I will definitely go and look at it. But I think it does show that we can't isolate these tools from their geopolitical context.
Thank you. Béligh, you have another example from the Cour de Cassation in France, right?
Exactly. And I wanted to say that probably not, I mean, geopolitics can be one aspect that can explain things. But the recent case by the French Cour de Cassation, in which the Cour de Cassation refused basically that the party choose Jewish law as applicable under Rome, although the parties were in France, they first engaged into arbitration, and then when the case moved to before the court, and then the court raised ex officio the question of the applicable law and said Jewish law, non-state law cannot be chosen. Like how this would fit within your theory, the theory that you developed, and now how you see things, like how, especially from, I mean, what is striking for me, particularly, I would love to hear your point of view on this. Like when you see the French Supreme Court developing a very liberal arbitral regime with transnational public policy and giving the party a lot of things, a lot of freedom and autonomy, even enforcing judgment that was declared void, annulled in a foreign country. But then when it comes to a very specific issue, non-state law and private international party autonomy and the law chosen by the party, then you see kind of conservatism that is very hard to explain. So you mentioned about incoherence already. So I would love to hear your view about this recent case law from France.
Well, I think that incoherence is the answer. I think also we have to, I mean, the Cour de Cassation, like any other court, is not a coherent whole. It's made of different actors. And I think that the arbitral autonomy promotion by the Cour de Cassation, who was so forward in bringing in freedom of arbitration, autonomy of arbitration clauses, etc., that may well be a time past too. In other words, the specific judges who had promoted that may no longer be there. So that's a question about the coherence of institutions. I'm not quite sure what the Cour de Cassation's position is today on these particular questions. But the case that you mentioned is fascinating. I think it's a mess. The difficulty, I think, I mean, it's a hypothesis that's fairly far from our general discussion about party autonomy in international commercial contracts, because first of all, one of the questions was that this was a French contract. This was apparently a French domestic contract. It does attract attention on what is a domestic contract and what isn't. but let's say that the parties were French and in France. And in this particular case, the parties aren't allowed to have Jewish law apply to their contract, although, of course, they were in conflict over this too, so that complicates matters. I don't see why Jewish law couldn't have been applicable. I think there's a bit of a mix-up in interpreting the provisions of Rome I in this particular case. There's no reason whether the contract is international or domestic. Rome I says, this is recital 13, that non-state law, and presumably including religious law, can always be incorporated into the contract as long as there's no contradiction with, let's say, the mandatory rules, here the domestic mandatory rules, of the normally applicable law. So these were domestic mandatory rules in a domestic contract, but of course it's exactly the same. It would be internationally mandatory rules in an international contract. So this is a question of incorporation, and I really don't see why this limit was put. Is it because politically there is a certain distrust, let's say, in French politics at the moment about religious law? Usually it's addressed to Muslim law, but here it's addressed to Jewish law. Why? I absolutely can't answer that. I think it was a mix-up in understanding the provisions of Article 3 of Rome I more than anything else. But I can't.
That is the comment I wanted to dare to make, especially this connection between Jewish law and Muslim law. So probably we can explain it on the one hand by sort of excessive formalism, by interpreting the rule of Rome I like in very formalistic manner. But there is also this political issue that you mentioned, and the idea like to providing a neutral and equal space where all religious law will be excluded, including Jewish law, even in this particular case, because if it were Islamic law, the same result would have been reached. So I'm glad you mentioned that, so, because I really thought about this at a certain point.
Obviously, my response is absolutely speculative. I have absolutely no empirical evidence of one thesis rather than the other. What we can notice about French politics at the moment is another reversal, or rather a consolidation of something that's always existed. In other words, that la laïcité is being more and more interpreted as a refusal of any religious connotation in the public space. Whether Jewish law is being used here as a pretext to eliminate Muslim law, that's also a kind of a cynical view, or whether it's just distrust of all religious law, I really don't know. But there again, the texts that were cited by the court don't support the solution at all. I think this has already been said. I think that Gérald Goldstein has already pointed this out very, very forcefully on his blog. But I think he's right. He's absolutely right. I don't know what happened there, nor how to interpret it. But I think that we can perhaps disconnect that from the wider debate about party autonomy in commercial contracts. I think this is less geopolitical than politics on the French domestic scene.
Thank you. Now let's talk a little bit about the future. We see a rising interest in so-called new commercial courts that are popping up all over the place, starting in Asia. I mean, it was I think the first was the London Commercial Court, but then after Brexit, everyone started to initiate its own international commercial courts, and Gérald has a question in this respect.
Oh, yes. You mentioned in your text the tendency by judges to act as if they were arbitrators, and therefore they are lacking the incentive to protect social interests beyond the parties to the contract. But then how do you think that problem would apply to these new international commercial courts? Because if that's the case, we are in a bad situation, because those courts are sprouting everywhere, and more cases are going to go there. Instead of going to arbitration, they are going to court. But if those courts are doing the same as arbitration, we are not in a better position. How could these courts go on? Are they a threat in general, or how would they act?
Fantastic question, and I can only speculate there again as to what the answer is, and I think it's probably a complex or composite answer. I think that the incentive structure, let's say, is the same. In other words, these are commercial courts who have sprouted in a competition between sites. So they might be national sites or they might be global sites, but they're attracting business. So once we're in that competitive paradigm, I feel my sort of distrustful approach is growing again. In that context, I don't really see the incentive for these courts to be taking social interests into account. On the other hand, because they're in a national competitive paradigm, there may well be part of the slippage that we were talking about, in other words, in a return to national interests. National interests aren't necessarily what is good for a global social regime or conversation. So I think that the direction might be dual. On the one hand, these courts are probably going to act like arbitrators because they're in a competitive paradigm and attracting business. On the other hand, they may well be promoting geopolitical interests at the same time. And that's a whole completely different incentive structure. So there again, I think we're out of this benign.
Is it us? So everyone can hear except us?
Hope so.
It had its a whole lot of defects, and that the courts could come back in for greater protection of the public interests. I'm not quite sure that that's actually implemented now in this sprouting, as you say. I think it's absolutely right. We see them everywhere now, and I'm not sure. I expect the Dataverse has got a lot of information on this, and I think that would be worth now comparing the case law that's coming out of these courts to see exactly where it's going.
One difficulty in this context is that not all of these court decisions are publicly available, but we are trying hard to get them. I know, for example, in the Netherlands, this new Netherlands commercial court, I think the decisions are not easily available. Neither are those from the Middle East, as Abu Dhabi and Dubai, and you name them. But of course, we're trying hard. Gérald, you had a follow-up question.
Yeah, as long as we are still in the spirit of competition, everything goes. Everything goes. There's no limit to what judges could do. If they want to replace the arbitrators, they will act, as you said, the same. And public policy will be very limited, I suppose, because they don't even have the problem of having their own decision recognized in their country because they are executable right away. So they don't have this problem that arbitral awards have. So they are totally free as long as they want. And the only limit might be to limit it, but they limit it actually to very expensive disputes. People have means, like they have to put $1 million to be able to sometimes go to these courts. And then it's like a discussion between a certain type of person. And everything goes, everything could go as long as this competition goes. But I mean, actually, if we take a look at who are in these courts, maybe we are wrong, because those people, I know some of them, they are very reasonable people. They are not crazy. I mean, if they are judges, they would respect the rule of law. They would try to respect the rule of law, and they will not go in all directions, I think. But it depends on who will become these judges. But they are judges, state judges. So there's a certain selection.
Not all of them. I mean, for example, in the Middle East, some in Dubai are renowned arbitrators that don't really have a judge formation or anything like that. So there is a risk.
I'm talking about
Sorry,
Singapore.
I took away your answer.
Okay. Okay.
Horatia.
Yeah, well, I certainly agree with Gérald. There's obviously the problem of potentially, the problem is that when you're institution building, even if some of the actors are virtuous, etc., the problem is the incentive structure in the system. And the same goes for arbitration, right? This was so beautifully described by Delazé and Gart. You had a kind of a very virtuous system with a handful of great arbitrators, and then now it's become an industry. It's the potentiality, I think, that we have to think about. What I would say is that I totally agree that as long as we're in a competitive paradigm, anything goes. Basically, that's what we can see in all sorts of fields. We can see it here in what Amina Hassani has described as the justice for capital. But we can find it in investment law. We can find it anywhere where there is a competitive paradigm, we have this same risk. And so this is why I responded fairly generally to Daniel earlier when he said, what can we do? What we really would have to do is globally unroot the competitive paradigm and replace it by the idea of solidarity. And how feasible that is, how feasible it has ever been, but how feasible that is now is probably beyond what we can imagine, I would say.
Yes, big question mark in that respect. To conclude this type of question, I would be interested in your opinion on whether the new Hague Convention, the Judgment Convention, can be a cure in reinstating, so to say, the second look doctrine that we were talking about earlier.
Yes. I mean, I think that was one of the points, that it was a unification of the judgment regime, obviously, that makes things more practical, but it does reserve the possibility, which is the standard tools, and particularly of controlling public policy. What I saw is that the Hague Judgment Convention was actually reignited after the 2000 sort of millennium failure by China. And you can see China's interest in reinitiating the negotiations and in implementing this Hague Convention all along the Silk Roads. This runs parallel to an arbitration regime, of course. And I think that it serves above all to make the Silk Road interoperable. But that's, again, we come up against this question of, we create a good tool, because obviously the Hague Convention, I mean, who can be against it? It's unifying, it's making things run smoother. We've got a good idea, but then we can never eliminate the twists in how things are used. And that would be the same answer I would have about mediation. We always have to be aware that nothing is written in stone and nothing is definitively a good thing or a bad thing. These are tools, and they're used in particular ways.
Thank you very much. Now we're already approaching the end of the hour that we have, and I would like to pass the floor to Benke for a closing question.
Yeah, thank you, Horatia. This is absolutely fascinating. And the reference to the Hague Convention is really interesting, especially because I read your article that you published on the critique on the geopolitical context. Anyway, so probably I would like to finish this by asking your vision about party autonomy. Shall we come back to studying it as a classical tool, or what is its role today, its future?
Well, I reckon that its future is ensured, so I wouldn't worry about its future. I might worry about the effects of it in the future, but I wouldn't worry about it as a tool. I think that when we're teaching and thinking about party autonomy, we must always remember to contextualize. And I think that's something that's valid for any tool. This is not merely instrumental. It has a signification in context. It has effects. And above all, I think we should never disconnect thinking about private international law from the wider geopolitical context. And that is changing so radically at the moment that it's really difficult to tell. I think that nobody can foresee what's going on. Obviously, we're past the neoliberal moment that I've been describing. I recognize that my analyses are probably completely out of date. I think that's the exciting part of things, that things are changing, and as lawyers and intellectuals, we have to try and understand exactly what the situation is, how these tools are being used. So as to party autonomy, I'm sure it's going to, as long as it's still useful and as long as it can still serve certain interests that are considered as important, whether good or bad, its future is definitely ensured. But I think it's really interesting at the moment, as you were suggesting earlier, to think about how China is using it, for instance.
I think
Yeah, I mean,
that's
the Chinese experience is actually very, very interesting, and there are some empirical research on how party autonomy actually apply, and the result or the conclusion was a kind of homeward trend, basically to apply Chinese law whenever possible. But do you consider like party autonomy should be more liberated, more constrained, or that depend on geopolitical context, as if I understood you correctly?
Yes, I think law has the way of reacting to a certain extent, at least, to these risks, and I think that's what we have to bear in mind. Absolutely, it may be also a case for greater reflection on the tools of protection. In other words, the whole idea of public policy. What does that include? Semantically, it's a very, very difficult concept, as we know. And so it means many things to many people. And it could just be reason of state. It could be a set of private interests. It could be many, many things. It could be an ideal transnational regime. But I think we need to pay more attention to that. I'm obviously not against private contract, private autonomy. I'm not myself in a sort of a planification mode. I think that party freedom is an important thing. I think there again, we just have to be aware of the way in which tools are used. Tools are never merely instrumental. And that's what we need to know, I think.
That is a wonderful closing remark, I think, for our discussion, which I enjoyed tremendously. I learned a lot, and I'm going to look at some of the articles mentioned in the review Critique. And I hope that the public audience here agrees with me that this was really a great discussion. Thank you very much Horatia Muir Watt, Gérald Goldstein, and Béligh Elbalti. We are now transitioning